We're trying to dramatize the Woody Copeland ex parte meeting, but it's been a bit challenging to get all of the voices right and make everything understandable because the transcript is a bit jumbled at times. Here we present the first part. If you all like it, let us know and we will produce the rest. Thank you. The concern that we wanted to bring to the court's attention as the state was twofold. One, we wanted to have the opportunity to impress upon Mr. Copeland with representation present that he faces, and we wanted to give him an opportunity to ask whatever questions he wanted to ask before he was we had to pull him in the courtroom when the jury came out. The second concern that I have is, and I wanted to bring to the court's attention in line with the concern that I expressed on the record on Friday, I don't know what advice counsel may have offered or may be offering. That is their right and their business. As it relates to testifying, however, I do not believe that criminal exposure is a concern which interest is being spoken about and protected. Mr. Melnick relayed to Ms. Hilton on Friday that he had never heard of the statute 24-5507, and on Friday he sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Shart. I don't know if he unintentionally put my name on it, but he sent an email to Mr. Steele and Mr. Shart with me, and Simone copied where he said, "This is the communication that I received from Miss Love regarding Mr. Copeland." My response was, whose interests are you protecting? Yours or Mr. Steele's? Whose clients? Which client are you protecting? Whose client, yours or Mr. Steele's and Mr. Shart's? He wrote back and said, "You are going to get him killed. You are making him a target. Fuck you," is what he wrote in the email. So given that his concern is that by testifying, at least the one that he conveyed to me in writing, his concern has nothing to do with exposure from the state. And if his concern, his being whose concern? Mr. Melnick. If the interest that he is protecting is Mr. Copeland's freedom, he did not convey it by asking us what exposure does he face in testifying. In fact, if he's concerned that testifying will get Mr. Copeland killed, and he is not communicating with us, he's communicating with counsel for defendants, it would seem that he knows a thing or something that we don't know. Additionally, and I will let Miss Bumpus tell you, he has said if Mr. Copeland testifies, he's no longer representing Mr. Copeland, which is strange because if your interest is your client, then it would seem you would want to be there for him while he is testifying. Well, he is on vacation this week. I understand. That is why he has. Miss Bumpus here, and he has said what he has said. And as I was reading the statute, I was reading the statute about this particular situation, and I was reading our rules, our ethics rules of conduct for attorneys. And it is clear that if an attorney, there were two things that were happening. One, Mr. Melnick had told me that he wasn't Mr. Copeland's lawyer. Mr. Copeland had told Miss Hilton that Mr. Melnick wasn't representing him. And then rather than Mr. Copeland reaching out to Mr. Melnick apparently was in communication with Mr. Steele and Mr. Shart. And Mr. Melnick reaches out to Mr. Copeland and injects himself in these proceedings. What we were discussing was in no way a matter that Mr. Melnick was representing Mr. Copeland on, and that is where we are not allowed to speak with a person when they are represented by counsel. Mr. Melnick could not have been representing Mr. Copeland on anything we were talking about, because we were talking about this case and this trial. All that aside, we would like an opportunity for the court to address Mr. Copeland with Mr. Copeland's stand-in counsel present. Miss Bumpus is looking at me like, I'm listening. With his stand-in counsel present and to allow Miss Bumpus an opportunity to explain to Mr. Copeland everything that I have just said. Her concern outside was what is the longest he can stay in jail. What I relayed to her is the statute says until he purges by testifying. His contempt by testifying. Yeah, 507 is a little bit different. So until the end of this, he can be here until the end of the trial. That is what I said. To the end of trial is the longest? No, it's not the longest. Even after a grand jury, if a person has been subpoenaed to testify before the grand jury, and even after the grand jury has, convened, has left, that person can stay in until that person purges himself of contempt by testifying. The statute literally says that. Well, I'm going to look it up because it was my understanding that it was until the end of trial. Nope. Here it is. Literally the words of the statute. And so, he could be in there a while. Let's put it that way. Either way, I just want to be able to give him, I know, it's kind of the statute says, that you purge, but I can't keep him in there indefinitely. I've got to right, that is all I want to know. The whole thing is that he has the keys to his own freedom, and that freedom is if he just gives his testimony, then he's purged it, right? And, whatever that testimony is, we know what we believe it to be, but, we don't know what it is. We can't talk about it. We don't, we don't know what he's going to say. We have an idea. We know what he's told us. Yeah. And our concern is that I know the court said essentially, you intimated that Mr. Melnick probably told him essentially, you should testify. They can't do anything with your testimony. But what we overheard being said was, they are going to hammer you, as if we were going to expose Kenneth Copeland to, you heard that? Yes, yeah. Mr. Melnick told Mr. Copeland, we're going to hammer him. Now, to be fair, and I think Ms. Bumpus, as an advocate or anybody, has got to tell him he's going to face some pretty significant cross-examination. Yeah, I think that's what he meant. He's got about 10, so he meant the defense is going to hammer him? No. Just in general, it's not going to be a, hey, da. He knew that. He had already been expressing that. But I think that if he's concerned about that, well, but it's all in the message and the packaging in terms of, I think Mr. Copeland is, a savvy person, but, he's certainly going to be subject to a thorough and sifting cross-examination. And the other thing is that, can I just say something in Attorney Melnick's defense in response? Just for the record? Yes. The reason that he doesn't want to move forward with representation, what I have been told, if he decides to testify, is that he doesn't feel like he can. He doesn't know what was said outside of his presence, so he doesn't feel like he can adequately represent him or counsel him because he doesn't know what was told to the state when he wasn't there. But the thing is that the only thing that he should be concerned about is the criminal exposure, or the exposure that Kenneth Copeland has criminally. And there is nothing. There is literally nothing. The statute is quite clear that we can do to him about. The only thing that would put him in harm's way is a lie and a refusal to testify after being ordered to do so by the court. And by a lie, we don't mean like, oh, I think you're lying. It would have to be, something obvious, because we can always impeach. But if he literally perjures himself, that's something different. We can't help that. We can't control that. We would only say, tell the truth. I don't care how bad it is, just tell the truth. So, like he says, I didn't go down to the police station. And I think part of his challenge, Miss Bumpus, may be that you need to assure him, look, I'm going to be here. And if you think that they are asking you a question, they being the state or the defense, is asking you a question that's going to bring out other crimes, that he's going to be able to look to you and say, can I have a chance to talk with you? That's exactly right. See, but that's just it. No, he's not. Hold on. That's just it, Judge. The problem is that there's been an assertion that people are representing, and I'm not talking about you. Yeah. There's been an assertion that people are representing that their biggest concern is his best interest, and then they are just not here. And Miss Bumpus is saying she's not in a position to do that. No, I'm not saying I'm not in a position. I'm saying that the agreement between Mr. Copeland and Melnick, who I'm standing in for, is that if he chooses to testify, I'm to get him to sign this paper that says that then discharges Melnick as his rep. That's their agreement. I can't do nothing about that. That sounds weird. That does not sound like something in Mr. Copeland's best interest. That sounds like protecting somebody else's best interest. If you talk, I ain't going to. I'm not going to represent you. I don't even know what to do with that. Well, he said he does not know what was said. It doesn't matter what was said. Right. It doesn't matter. And he didn't ask us. He didn't even inquire, what have you all talked about? He has been talking to Brian Steele and Max Shart. That's it. He is not talking to us. And in fact, when Mr. Copeland asked to speak with us, Mr. Melnick barges in and gets between Miss Hilton and Mr. Copeland and literally keeps us from talking to him before he gets called to the stand. And that's troubling. Well, I think what happened was, and I say this because I previously represented Mr. Copeland previously on his other stuff. So I know this is just what I think happened. I think how Attorney Melnick came involved was his representation of other because he took my place. Copeland fired me and hired Melnick, and then this came about. And I think so at the beginning, Melnick was representing him, and then in his criminal matter that he had, but that's resolved. But when this case started, Melnick called me and told me that he was representing him as a witness at the beginning. I can assert that.